All right, please. Please be seated.
Good morning. Hereby I open this academic ceremony in which Xiaoli Xu will defend the academic thesis, The Role of the Courts in the Field of Climate Change in China, an analysis of regulatory and judicial approaches. May I invite you to present a summary of your study and the conclusions of your thesis.
Thank you. Good morning, dear prorector, supervisors, committee members, dear colleagues, family, and friends. It's a great honor to stand before you today to present my research, which concerns the role of the courts in the field of climate change in China. The analysis focuses on the regulatory and judicial approaches. In the following 15 minutes, I will first introduce the background information of climate change litigation in China. Then it comes to my main research question and methodologies I used to analyze it. And after that, I will summarize main findings, and the conclusion will be given in the end. Over the past decade, climate justice claims have increasingly been brought before courts worldwide. And one famous example is the Yohinda case, in which Dutch NGOs, as well as citizens, successfully required the government to strengthen its mitigation targets. Another recent case happened in Switzerland, where a group of elderly women argued that insufficient climate action taken by the government violated their human rights under the European Convention on Human Rights. And as shown in the Summit Center database, climate litigation has emerged in mainland of China. In China, the central government announced important climate pledges in 2021, including reaching carbon peak by 2030 and achieving carbon neutrality by 2060. To support these goals, China has issued various policy instruments covering both mitigation and adaptation measures. In this thesis, I focus on mitigation, which means especially on the reduction of greenhouse gas emissions and the enhancement of carbon sinks. However, the legal framework for climate mitigation remains relatively underdeveloped. And in this context, courts have been involved in climate governance. Here, people may raise questions like, how is climate change litigation practiced in China? But before answering this question, I will first clarify what counts as climate change litigation in this study. Maybe you have noticed the examples I just mentioned are typically well-known cases. However, climate change litigation is not limited to these high-profile cases. Many climate-related disputes do not explicitly refer to climate change, but they may still influence climate mitigation. And such cases would be excluded from the climate litigation research if we adopt a very narrow and strict definition. To answer this issue, my thesis distinguishes between two categories. So narrow climate change litigation refers to cases in which facts or legal arguments related to climate mitigation are directly and expressly raised, either in the pleadings or in the judgments. While broad climate change litigation refers to cases while not expressly invoking climate change mitigation in their legal arguments or factual basis, nonetheless engage with state mitigation policies and may influence climate targets through indirect approaches. After clarifying this distinction, I will now introduce research questions. The main research question is, how can courts in China, given the existing legal framework, address climate change issues? And this main research question was further divided into 3 sub-research questions. The first one is, to what extent has China established regulatory instruments regarding climate change mitigation? Second one is, what opportunities and challenges does the Chinese legal system present for climate change litigation? And third is, how do Chinese courts interpret and apply existing laws and legal principles in addressing climate change cases, and what role do these cases play in shaping the climate governance? Now, I present the methodologies and the structure. This research adopts a legal doctrinal method, analyzing legislation, doctrinal literature, and case law. Specifically, the Chapter 2 is working on answering the sub-research question 1, reviewing the Chinese regulatory framework contributing to climate change mitigation. Chapters 3 and 4, functioning as bridging chapters, are designed to jointly analyzing the opportunities and limitations of the Chinese judicial system to address climate change issues. But their research resources are different. The discussion of Chapter 3 is mainly based on the judicial interpretations and the judicial opinions issued by the Supreme People's Court, while the discussion of Chapter 4 is highly relying on the academic literature. Then Chapters 5 and 6 focus on case analysis in order to investigate how courts address climate issues and play a role in climate governance from a narrow and broad climate change litigation perspectives, respectively. Here we move to answer the first sub-research question. Chapter 2 examines 3 mitigation approaches, which are the emissions trading system, the natural carbon sinks enhancement, and the renewable energy development. I here set 3 criteria for the assessment. The analysis reviews that, first, in terms of alignment with national climate mitigation targets, the ETS regulation directly addresses greenhouse gas emissions, whereas instruments governing the forestry and the renewable energy contribute to mitigation as co-benefits. Second, regarding the clarity of legal preventions, the ETS regulation establishes a relatively clear legal framework, such as for the allowance allocation, the trading, and the compliance, while the relevant provisions in the forest law and the renewable energy law remain largely principled, with their clarification and interpretation largely relying on subsequent administrative measures and administrative normative documents. Third, with respect to the enforceability, the ETS regulation has binding legal force, although its effectiveness of enforcement still depends on the capacity of the local government to ensure the compliance. The other 2, affected by the limited legal clarity, rely mainly on administrative coordination rather than the enforceable legal obligations. Hence, overall, the answer to the first sub-research question is that China has established several mitigation instruments, but regulatory gaps still exist in the legal framework. And this creates potential space for climate change litigation. Then I want to figure out what courts can do in this field. To answer this second sub-research question, Chapter 3 examines the general gap-filling role of Chinese courts and how they interpret law when legal preventions is incomplete. It shows that Chinese courts are capable of interpreting unclear legal rules on a case-by-case basis and they are encouraged to pursue the unification of legal, social, and political effects in their adjudication. And second, the Supreme People's Court has issued specific judicial opinions on the climate change litigation, encouraging courts, not only the environmental courts, to treat national climate targets as important considerations in their judicial reasoning. Chapter 4 turns to discuss the practice of environmental public interest litigation. The analysis shows that environmental NGOs and prosecutors may initiate civil appeal against companies' greenhouse gas emission. However, it is hard for plaintiffs to prove the damage or risk caused by greenhouse gas emissions. And in addition, it's also hard for them to establish the causality between specific emission activities and particular damage or risk. For administrative appeal against the government, prosecutors have the standing to challenge specific administrative actions, but only when clear legal rules define the legal obligations of competent administrative authorities. Hence, overall, these two chapters demonstrate that Chinese judicial system provides a limited but important opening for the climate change litigation. Then I turn to answer the third sub-research question, analyzing how courts address climate issues in narrow and broad climate change litigation. Chapter 5 examines 4 narrow climate litigation cases identified through the sub-center database and the Chinese academic literature. These cases include the Gansu case, Ningxia case, power generation company case, and the Bitcoin mining case. After analyzing the statement of the parties and the court's reasoning and rulings, 4 main findings were identified. First, 3 of 4 cases were brought by NGOs through appeal, in which plaintiffs primarily sought the enforcement of existing legislation. They also claimed ecological damage compensation. However, in all 3 cases, courts kept silent on this compensation issue. Second, in 2 cases, courts explicitly referred to the national climate targets when interpreting and determining the environmental public interest, and based their decisions in part on this reasoning. Third, in all 4 cases, the defendants were companies rather than the government. And finally, in terms of the litigation outcomes and practical effects, these cases helped to some extent to address administrative enforcement gaps. Therefore, to summarize, Chinese courts focus on enforcing existing legislation rather than seeking to fill the legislative gaps in a narrow sense. However, in certain cases, they do rely on non-binding climate targets and policies to interpret unclear legal rules. Chapter 6 examines broad climate change litigation through typical cases issued by the Supreme People's Court. The analysis shows 3 main findings. First, climate-related disputes in broad climate change litigation are not limited to specialized legal areas, such as the environmental law, but may be found in many areas of the law. Second, courts have indirectly supported the implementation of national climate policies through their interpretations of legal provisions and rulings on forms of liability. Hence, these cases show that Chinese courts have the capacity to contribute to climate governance. However, when climate-related interests come into conflict with other important societal interests, courts do not treat them as having absolute priority. In cases relevant to governmental decisions, courts typically do not directly interfere with governmental decision-making or challenging existing climate policies. Finally, I present the conclusion. This research found that given the Chinese insufficient regulatory framework and its legal culture, the judiciary plays a facilitative but cautious role in climate governance. And to summarize, judicial support for climate change mitigation is real but careful, reflecting the dual role of courts in both adjudicating disputes and supporting governance-oriented climate initiatives. Thank you very much for your listening. I will give the floor back to the rector.
Thank you for this presentation. The opposition will be opened by Dr. Vos, Professor of European Union Law at Maastricht University.
Thank you very much, dear candidate. I would like to congratulate you with your wonderful work, with the book you have written. I think it's a wonderful contribution to explain how courts work and how courts can contribute to such important topics as climate change. But I'm not here to praise you only, but also ask you some questions. So my question relates to the precautionary principle, as you may not be surprised. You explained that some authors have read the precautionary principle in Articles 39 and 47 of the Environmental Code and state that this principle has also been inserted into the draft Environmental Code as a fundamental and independent principle for addressing climate change. You argue then, actually, in your thesis, that the core threshold of the precautionary principle in international law is the threat of serious and irreversible damage and the lack of full scientific uncertainty have been simplified into the concept of significant risk. I find this quite odd, I must say, well, with my knowledge of the precautionary principle, especially how it works in the European Union and European Union law. I wonder whether you can still then speak of a precautionary principle. I would like to ask you to elaborate on this. Thank you.
Highly esteemed opponents, thank you very much for your compliments and questions. The precautionary principle is a very important principle in the environmental law system. But I have to say, first, the precautionary principle has various versions across different jurisdictions. And as you said, in general, precautionary principle was triggered by three elements. But I would say in China, the prevention in the Chinese linguistic context, the prevention is very broad, and sometimes it contains both the meaning of preventive and precautionary. So before the ecological and environmental code has been issued this year, the precautionary principle has not been clearly stated as a standalone principle to address environmental issues, but it has been reflected in judicial practice because in the judicial interpretations, the Supreme People's Court has stimulated that in certain cases the courts can take some precautionary actions to prevent further harm or damage. So I think that's a different understanding of, and also the different development pathway of precautionary principle in EU legislation and in Chinese legislation. I hope I answer your question.
The opposition will be continued by Dr. Bauer from Durham University in the United Kingdom.
Thank you. Can I just start by saying congratulations on producing such a fantastic piece of work, and thank you very much for involving me in your defence. Of course, I'm very interested in the study of climate litigation, and I'm certainly very interested in perspectives that challenge the mainstream. And this thesis does that, partly by its focus on Chinese litigation, but also I think it brings a very fresh and thorough approach to the field. I like the consideration of a broad range of case law, including the mundane disputes, and I like the very strong emphasis on the law and how a consistent focus on the decisions being reached fits within a current legal system, and how this shapes both their potential but also their outcomes, because I think often the law gets forgotten. So still thinking about the law, I liked that the possibilities for regulation are set up within a discussion of climate and energy governance. And this is the focus of my first question. So please could you speak more about the connections between the regulation discussed in Chapter 2 and the case law? So I appreciate a perfect compliance relationship cannot be established, but you do claim that the cases implicitly align adjudication with climate change policies. So please could you speak to this alignment? Just give us more, and you can answer this any way you wish. So either focus on a particular case or a particular piece of regulation, but could you just illustrate this alignment for us, please?
Highly esteemed opponent, thank you very much for your compliments and questions. I would like to first paraphrase your question. You would like me to clarify or explain more about the connection between the regulatory framework, which I discussed in Chapter 2, and the case law case analysis in Chapters 5 and 6, right?
Yes, in terms of how it helps with alignment with climate policy. And like I say, focus on any aspect you want to. That's
with the alignment with the national climate targets?
yes.
Okay. Thank you very much for your question. I think as I present in the presentation, the regulatory framework in China is to some extent established, right? There are some mitigation instruments contribute to climate change emissions reduction and also the enhancement of carbon sinks. But to be honest, I have to admit that a lot of legal rules are incomplete, and its application still relies on the further interpretation of courts or rely on the further clarification on the by the administrative measures or administrative normative documents. And in the judicial work, even though the lack of the legal clarity or the enforceability to some extent, courts have to adjudicate disputes, right? And they have to interpret, they have to base their decisions directly on the clear legal rules. But when there is a legal gaps or the legal rules is not super clear, they have to interpret them. And in this process, Chinese courts decided to take climate policies as well as climate targets as contextual consideration to identify fact or to interpret open legal norms to give them more specific meanings in specific case level. So I think through this way, to some extent, the decision is legitimate, and to in another perspective, the outcome of adjudication keep in line with the national policy. So I think through this way, these cases help to implement the climate policy and help to achieve the climate targets. I hope I answered the question.
Cool, thank you. Could you just give us an example, though? So an example of a case compared to a piece of regulation.
You want me to give specific examples?
Yeah.
Such as in the power generation company case, which is a very recent case in China. In this case, the direct legal basis is the ETS regulations. But this case was initiated through the environmental public interest litigation by the environmental NGOs. And in this case, the court of first instance clarified that the incompliance of the company to surrender sufficient emission allowances violated the environmental public interest. And since this regulation are closely relevant to climate change mitigation, such incompliance violate the climate targets, the national climate targets. So that's why the court reasoned the company to fulfill its obligation to surrender sufficient emission allowances. And I think the court helped to reduce the administrative gaps, because before the cases were filed, the administrative authorities have issued warnings several times, requested the company to surrender their allowances, but they failed. And this case, before the final judgment issued, the company has purchased and surrender sufficient allowances. So if we look at from the outcome perspective, I think it filled the administrative gaps and align with the national climate targets. Thank you very much.
The opposition will be continued by Dr. Xi Ping, who is professor of environmental law at Sun Yat-sen University in China. She is online.
Thank you very much. First of all, I would like to congratulate to candidate to finish an excellent thesis. It will be of great help to readers, including myself, in understand the role of Chinese coal play in addressing climate change. My question is, despite the Chinese coal to active participate in climate governance, could you please make a conclusion? Are there any limitation of Chinese coal in addressing climate change, especially from the case law study?
Highly esteemed opponent, thank you very much for your compliments and questions. I think based on the case analysis in chapters, especially in chapter 5, focus on the narrow climate change litigation, I think the limitation of Chinese courts to address climate change litigation is obvious and is visible, because especially when we look at the compensation issues, as there is no, firstly, as carbon dioxide is not identified as air pollutant, so there is no methodology to count the damage, the specific damage caused by the greenhouse, caused by the carbon dioxide emissions. So for court, it's a big hurdle to assess such damage, because there is no very liable assessment, especially in the Chinese judicial system. But the court do not trying to fill the such gaps, we could say regulatory gaps, or they do not trying to address this issue, and they keep silent on it. So I think they leave the discretion to the government to develop, to further develop specific methodologies to address this issue. And another Another big limitation in the Chinese judicial system, while not reflected in the case analysis in Chapter 5, is the causality issue. But this causality issue is a common hurdle across different jurisdictions, and I think Chinese courts do not answer this question. So, yeah, I think there are indeed some limitations still exist in the judicial system. I hope I answered your question.
Yes, thank you very much.
The opposition will be continued by Dr. Fouwe. He is Professor Emeritus of Comparative and International Environmental Law at Maastricht University.
Mrs. Candidate, also from my side, congratulations. I have followed your work for more than 4 years. We have discussed often about your work, so I was not surprised to see a wonderful, interesting, high-quality overview of climate change policy and the role of the courts there. Now, Mrs. Candidate, when we talk about climate change litigation here in Europe, what are we often talking about? We think about cases like Urgenda, Greenpeace, Bonaire, and so, where we see judges intervening, where we think that the regulator or administrative authorities do not do enough, and then we are pleasantly surprised sometimes that judges do something what administrative authorities have not done. You define that as the small climate change litigation, but then you present a couple of cases, and then I get a bit surprised if I read this interesting Green Peacock case, a case of broad climate change litigation. You describe it on page 250 and following of your book. There is a region where they want to build a first-class hydropower station, but it is the key habitat for the green peacock, a nationally protected first-class species, so very important. And there is an NGO, the Friends of the Nature, that file an environmental public interest litigation, and in first instance, in the Kunming court in Yunnan, they win their case. But then it goes in appeal, and in appeal, the court of second instance says, no, these are legal issues that fall entirely within the territory of administrative authorities, and they say, the decision whether or not to halt such a project should be made by the relevant administrative authorities, and this is absolutely not something that the courts can intervene. Courts are not legally mandated to intervene. This all falls within the authority of administrative agencies. And it goes to the Supreme Court, but the Supreme Court upheld this decision of the Court of Appeals. Now, here, Mrs. Candidate, of course, a couple of questions come up then. If it's so that indeed the courts cannot act to review or to act against regulatory authorities or administrative authorities, is it then so, to put it bluntly, that the classic climate change litigation Urgenda style does simply not exist in China? If you cannot challenge decisions of administrative authorities, then what is the point, to put it simply? But second, Madam Candidate, should you or could you not have been slightly more critical? As a good Chinese, you describe the case, and you then have a little section where you say reflection, but even in the reflection, you do not provide any critical perspective. And even from a legal perspective, couldn't you say that the courts could, for example, use legal principles like subsidiarity or proportionality to review what administrative authorities have done? So, Mrs. Candidate, I would like to invite you to reflect on this case, perhaps in a slightly more critical way than you have done in your book. I'm looking forward to your reaction.
Highly esteemed opponent, thank you very much for your compliments and questions. Yeah, I think Green Peacock case is a very interesting and important case in China, both from the precautionary principle approach way and the broad climate change litigation identified in my case. I think based on my discussion in Chapter 4, in China, citizens, of course, can initiate private administrative litigation against the competent administrative authorities, but only based on these specific judicial actions violated their private interests. And in the realm of public interest, only prosecutors have the standing to challenge against these specific actions taken by the government. So in China, I would say, based on the administrative judicial system, it is less possible to initiate cases against the government, like Yuhenda case. No, the court will not directly challenge the national climate policies or the challenge regulations. So I would say that's the difference of the jurisdictions. And in the practice, based on my research, I think Chinese courts can review whether when determining the cases, they can review whether the regulations or administrative measures is appropriate or not, and they can decide whether to use them to make the decisions, but they barely directly make a decision on whether this policy or regulations is appropriate or not. So they do not conduct a judicial review on the general administrative actions by the government.
And do you think they should?
Well, because the social governance system is different, they are not authorized such power to do that thing. So I think that's the balance between the judicial and the executive power in China. So they do not.
Thank you very much. I will not tease you further.
Thank you.
The opposition will be continued by Dr. Coppens, who is Professor of International Economic Law at Maastricht University.
Dear candidate, I would also like to join my colleagues in congratulating you with this truly excellent thesis. It places a much needed spotlight on both the potential, but as we have heard also, on the limits of climate litigation in China, and it interplays indeed, it shows the interplay with climate policy. As a European scholar, I found it really intriguing to see what a different role courts play and how they complement Chinese policy. Like I think the Chinese courts themselves, your reasoning is careful and cautious, but at the same time also coherent. So I think the book deserves a place on the shelf of everyone interested in climate litigation in Europe, in China, but also beyond. Before putting it on my own shelf, I would like to ask you a question, however. You assess China's compliance with its obligations under the Paris Agreement, and separately you also discussed the recent landmark ICJ advisory opinion on climate change. In my question, candidate, I would invite you to connect the dots and explain whether the ICJ advisory opinion has any implication on whether China complies with its mitigation-related obligations under the Paris Agreement, and do you believe that China, in response to this landmark advisory opinion, will indeed strengthen its mitigation policies? Thank you.
Highly esteemed opponent, thank you very much for your compliments and questions. Yes, I would happy to say that ICJ gave a very important advisory opinion on states' obligation to mitigate, to address climate change issues. And I do include this document in my concluding chapters. I think it provides a very good external, like international legal development to place Chinese mitigation, climate change litigation inside this broader context. I think ICJ's advisory is definitely important because even though it's not legally binding, it is authoritative because ICJ interpret and clarify at least the international customary law, which applies to all states and including China. So I would say first, ICJ's this important document would not have a very direct implication on the Chinese courts, because in China, the Chinese courts typically do not directly refer to the international law or international judicial documents in their reasonings, but they based their decision on the domestic law. So there will not be a very direct approach to influence. However, I do think it will have some implications on China, because under the international climate legislation, both under the UNFCCC or Paris Agreement, states are obliged to take some appropriate actions to mitigate climate change with the highest possible ambition and in light of their national circumstances. So I think follow this such kind of, if we could say, principles, Chinese government and China has adopted several approaches, including both policies and legislations. And especially in China, China adopted a state-led approach to mitigate, to regulate the greenhouse gas emissions. There are a lot of abundant of policies and supplied with some incomplete mitigation regulatory instruments. And since policymakers and legislators will take this ICJ's advisory opinion into considerations, so they might issue more stringent policies on mitigation, or to revise existing legislation, or even enact new law to regulate the greenhouse gas emission as well as the enhancement of common sinks. And through this way, these policies and legislations will have direct and indirect implications on the Chinese courts. Like I said, Chinese courts can take these policies into considerations when interpreting, when identifying facts or interpreting some open legal norms or incomplete legal rules, and they based their decisions directly on the existing legal rules. So yes, there will have implications on the Chinese courts, but yeah, since this advisory opinion is very new, and I think its implication still needs to be studied in future, to maybe through empirical research or other research method. Yeah, thank you very much. I hope I answered your question.
The opposition will be continued by Dr. Kashni. She is an assistant professor and specialized in energy law and works at Maastricht University.
Dear candidate, first of all, I also want to join the congratulations on this major academic milestone. It was a pleasure to read your dissertation. I was particularly intrigued by your analysis on Chinese energy law and the integration of renewable energy sources, where you highlight in chapter 2, section 344, how Chinese energy law heavily relies on objective-based legislation through these broad aspirations and targets, but it also has principles, like the green principle that extends to energy efficiency, and to a lesser extent also rules, like the quota system that you've highlighted. Therefore, my question is, how does the role of the judiciary differ when enforcing these objectives in comparison to principles and more specific rules? And to which extent does that then, this kind of like regulatory design choice, shift the responsibility from the legislator to the judiciary when it comes to effective legal enforcement? Thank you.
esteemed opponent, thank you very much for your compliments and questions. Could I invite you to paraphrase your question? I did not quite follow the...
So basically, how does the difference between, or like how does this heavy reliance on energy objectives shift the responsibility from the legislature to the judiciary when it comes to legal enforcement? And how does this then differ if we would rely more on principles and rules?
Yeah, thank you very much for your clarification. I think the responsibility will not shift from the legislature to the court, especially on this energy objective, because firstly, I would say the regulatory instruments on the renewable energy development is principled, and their application, let's put it another way, the Chinese government set up a lot of specific objectives for the renewable energy development, but these goals are not legally binding, like written in the legislation. So their application highly rely on the administrative measures or administrative normative documents, or even some policies rely on the performance, the administrative coordination rather than a clear legal obligations. So that's what the legislature have done. But I think since China adopted a state-led approach to mitigate, so I would say it is effective to realize these obligations through the executive way. And in this process, Chinese courts may integrate these energy objectives into their reasonings to take their goals as a background contract consideration when they interpret such as green principle, open legal rules, and then make decisions. So I think I would say they play a supplementary role to implement, to realize these objectives, but they are not the first class to achieve this. And they do not hold the first priority responsibility to realize such kind of objectives. Thank you. I hope I answered your question.
The opposition will be continued by Dr. Bauer.
Thank you. So I have another question for you. In your concluding chapter, you comment briefly on the general field of climate litigation in Global South countries. And one thing that struck me when I read this is most studies of Global South climate litigation focus on former colonies, and so focus on what are doctrinally and culturally pluralistic adaptations of common law and civil law cultures. In your conclusions, you observe that China has a distinct judicial culture and distinct legal traditions. So my question is, could you please explain how the legal culture and institutional design of the Chinese courts make this a distinct area of study? And explain why there might be limited scope for cross-fertilization between even other, either basic countries or Global South states. If you think that's correct, if you don't, explain why there is scope for cross-fertilization. And why, nevertheless, understanding climate change litigation is important for global environmental scholars. So speaking really to the contribution your work makes to the broader field.
Thank you very much for your question. Yes, I gave a very brief introduction, not a, could say, discussion about climate change litigation in the global south, but I put such kind of discussion in the concluding chapter because I want to give a brief comparative insights to compare the role of court in China and the role of court in other jurisdictions, because, yeah, like I said, the role of Chinese courts is highly determined by its legal culture. So in China, the role of the courts is deeply embedded in a judicial culture, characterized by a limited judicial discretion, and especially for the climate change mitigation, the state adopt a governance-oriented approach. So when conducting judicial interpretations, the Chinese courts inevitably to be influenced by such character. So that's why they trying to firstly apply existing legislations and interpret unclear legal rules while take national policy and targets into considerations to clarify these open legal norms. And also they trying to, since they are encouraged to pursue the unification of legal, social, and political effects in their adjudication, so their adjudication shows a trend. I think it's too quick to say a trend. They're trying to align their decision with the state policy, let's this way, and seek the coherence between the three different effects. So I think that's the logic of the activities of Chinese court. But I would say in for climate change litigation in global south, there are a lot of strategic cases because they also, all the citizens or NGOs are trying to, on the one hand, to enforce existing legislations, also to package the climate claims with other environmental issues and to push their government to revise or strengthen their mitigation targets or approach or actions. But a big difference is in China, in climate change litigation in global south, there are a lot of human rights-based cases and constitutional rights-based cases. But that kind of cases are barely happened in China. So I think that's the big difference between, even though China also, belong this group of global south, there are still some different inside. Yeah, because their character, they are embedded in different judicial character.
Okay, thank you. And then the second sort of part of the question was really, can you speak to the contribution your work makes to the global field? So why would a global environmental scholar need to know about climate litigation in China? What are you adding to the global space?
Thank you very much. I would say first, as China is a very big emitter in the world, so There are something happening in China. I don't, because there are some linguistic difference, so many like European scholars or American scholars do not familiar with what happened in China. So I want to introduce the exact things happened in China, like say climate change litigation already happened in China. And even though based on the emerged case law, there's no claim to argue the government to revise their mitigation goals or adopt more ambitious mitigation approach. The courts do something. The courts help to to interpret the unclear legal rules and let's say fill the legislative gap in a specific case level. And they help to, such kind of judicial work can contribute to the formation and transformation of the Chinese climate change law, because after this case happened, the Supreme People's Court may detect and identify these important cases and release them as typical cases or guiding cases. And these cases have implications on future similar disputes on their adjudications. And the Supreme People's Court may also issue judicial interpretations to clarify unclear legal rules and also to fill the legislative gap if there is no exact legal rules to address climate change. But yeah, the things have emerged before the court, and the court needed some legal basis to make decisions. And finally, all this judicial practice might codified in the black letter. So I think climate change litigation practice may contribute to the formation and the transformation of Chinese climate law. And well, I would say China also gave insight in such a country with limited judicial discretion, what court can do to even small effort, they still help to contribute to the realization of climate goals and to help to correct the activities of companies. Yes, I think that's kind of contribution of my research and also the Chinese climate change litigation. Thank you very much.
The opposition will be continued by Professor Faure.
Thank you very much, Mr. Rector. Madam Candidate, I'm also going to ask you a question on your last chapter, the conclusions, because there is a lot. You talk about positive perspectives on strategic climate change cases, skeptical perspectives. There we see Benoît Mayer and Alexander Zahar passing, and it continues a little bit like that. Reflections. The thing that I missed, the section in your conclusions, what we often have in a thesis, is recommendations. And so now I would like to invite you, what are in fact the recommendations that you make as far as China is concerned for the role of climate change litigation in climate policy? Looking forward to your reflections.
Thank you very much for your question. Yes, I did not give a recommendation in the concluding chapter, but that's kind of choice by me, by myself, because in this study, in this research, I would like to discuss, to investigate what courts can do, yes, to explain the legal practice in China. So I focus on the prescriptive part when doing this doctrinal research, and I do not trying to give a very prescriptive claims like what's the appropriate role can Chinese courts can do, but I could give some reflections of how could Chinese courts improve their role. Like they can make fuller use of the existing legislations, like the legal principles to interpret these open legal norms in their adjudications, and they can also help to correct the non-compliance, and to reduce the administrative gaps. And they also can help to articulate more clearly in their reasoning how they connect the climate.
Thank you. Xiaoli Xu, the degree committee here present, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. And I request that you and your company await the results of our deliberations and return to this room.
Please be seated.
Xiaoli Xu. The degree committee here present has assessed the quality of your thesis and your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Peters is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I invite your supervisor to now take the floor.
All right, please.
Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible? By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Xiaoli Xu, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university. Do that together with Niels.
Ja. Please be seated.
Esteemed Dr. Xu, dear Xiaoli, it is such a great honor to congratulate you with this magnificent result, the successful defense of your PhD, with which you have obtained now the title of doctor. I am very glad we could successfully conclude this super nice and important research project, in which also Professor Niels Philipsen was involved as co-supervisor. Niels will also address a few words to you in a very short while from now. Dr. Xu, our cooperation started about 6 years ago. The very first meeting between you and me was initiated by you in a most peculiar way. It was in November 2019 when I was lecturing at the Research Institute of Environmental Law at Wuhan University in China that suddenly something unexpected happened to me. While I tried to concentrate on my lecture with all master students seated in the classroom, nicely answering some questions I had, suddenly one of the students stood up, raised her hand, took the floor and submitted a challenging question to me. This was Xiaoli Xu, not even a student at Wuhan University, but at Xiamen University. It appeared you took the plane all from Xiamen to Wuhan in order to try to catch my attention so that you could discuss whether you could start a PhD project at Maastricht University. Your proposal was clear and direct, almost very Dutch. You said, I want to write a PhD thesis with you on climate litigation in China. Your bold attitude at that decisive moment showed already your courage, dedication, and motivation. On the same day, we went to a nice vegetarian restaurant near the campus, which provided an opportunity for me to get to know you better. You were very determined, willing to write a PhD on strategic climate litigation in China, even without any research funding. Already that evening, I became confident that you were a very good candidate for a PhD. Then the fact that your master thesis supervisor, Professor Zhu Chen from Xiamen University, sent me a letter with her recommendation confirmed my willingness to give it a try. The confidence was even further enlarged since Professor Zhu Chen knew what it would mean to do a PhD in the Netherlands, since she did a PhD in Tilburg and was supervised by my dear colleague Jonathan Verschuren. This all contributed to my faith, and today We celebrate your courage and dedication to undertake this endeavor. Of course, in the project there were some difficult moments, as happens more often with PhD projects. In the first half year, we had to try very hard to seek the best research approach. Your original idea was that China should follow the strategic litigation trend that was started in the Netherlands with the famous Agenda case from 2015. Your attitude was, if I may say so, a bit more activistic than academic at that time, which is as such understandable given the seriousness of climate change. Fast forward 6 years later, we can conclude that we together, also with the help of Niels, found the right approach to discuss the role of the Chinese courts in climate change matters, for which studying the regulatory approaches and the specific legal system in China were essential. As far as I know, this is really the first book that discusses the Chinese climate law in such an analytical and comprehensive manner. I am proud, Xiaoli, that you were so courageous and dedicated. However, in the foreword of your PhD, you honestly talk about stressful moments you had. Well, today I would like to state that it is really great that you have learned how to cope with the emotional challenges of doing such difficult research. I want to share with the audience that they actually have seen a very strong woman, full of passion to investigate the role of law for dealing with the climate change problem, and willing to perform in the best way. You found your strategies of how to cope with the stress, such as teaching yourself how to do boxing. And while you have indeed completed the project, I truly think that you have achieved the best result possible. Thank you, Xiaoli, for the book and for our nice cooperation that will hopefully continue. And I now give the word to Niels.
Thank you. Dear Dr. Xu, dear Xiaoli, I want to add just a few words to those of Marianne. I stepped in as your second PhD supervisor about a year after you started in the beginning of 2022. Your original second supervisor, Professor Vos, had to step down due to having too many other commitments, most importantly those of leading one of the biggest departments at our Faculty of Law at the time. Fortunately, that original supervisor today takes up a different role. So my contribution to the supervision primarily was to keep an eye on the methodology, progress of the research, and on the presentation of your analysis. When one has Marianne to overlook the environmental law part so diligently, who needs another supervisor to check whether the legal analysis is thorough? Fortunately, though, I happen to know a thing or two about China and its institutions, so my supervision focused also on that and could thereby complement Marianne's knowledge. Another concern of mine, as with all the PhD researchers I supervise, was to make sure that you were integrated well within the faculty community. That turned out to be easy. Of course, you've been a member of the European Law Department, but you also joined METRO, to which both Marianne and I were affiliated, and Professor Faure in the committee today. And you fitted in very well there, among the many colleagues working on environmental law or on different topics related to Chinese law. I want to highlight here your active participation in that community and in the faculty. You participated in many of the METRO seminars and social events, attended the Faculty of Law Christmas parties, and fitted in very well with the PhD community of our faculty and beyond, particularly the CSC community. I'm sure that many people will miss you here in Maastricht. Besides attending events, you also presented your research to colleagues at seminars, at the Jus Communi events, and beyond our faculty community, of course. You were also one of the volunteers to teach Maastricht students in the autumn of 2023 in an extracurricular course, Introduction to Chinese Law, more specifically on the topic of Chinese environmental law, with nearly 100 students in the audience, and that in the evening. In short, congratulations on your achievement today and your contributions to the academic community. Finally, I will attempt to say in Chinese how proud Marianne and I are of those achievements and contributions, considering also that your mother came all the way from China. Xiaoli, 你的家人，尤其是你的母亲，会为你感到非常骄傲。我和Marianne也为你感到骄傲。我们祝愿你事业蒸蒸日上，也希望我们能保持联系。Congratulations.
Dear Dr. Xu, also on behalf of Maastricht University, I congratulate you with the degree you've acquired and congratulate your mother and family. I also wish to thank the members of this committee, and in particular Dr. Bauer and Professor Xi Peng for being here. And of course, congratulate your supervisors for this great result. We'll now have 2 photo opportunities, one here, and hopefully Professor Xi Peng will be on screen. And after that, we go to the hall. You're kindly requested to wait until we've left and then to go to the reception room for the drinks. And I conclude the session.